Warm greetings to one and all present. I hope everyone is doing well. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be sharing my views on the topic Protection of Minority Rights under the Indian Constitution. Let's start with a brief introduction. Minority rights are protected under Article 29 and 30 of the Indian Constitution. It guarantees the cultural as well as educational rights. Article 29 Clause 1 secures to every section of citizens residing in the territory of India the right to conserve its own language, script or culture. Article 30 Clause 1 guaranteed to every linguistic or religious minority the right to establish and administer the educational institution of their choice. The object behind Article 29 and 30 is the recognition and preservation of different types of people with diverse language and different beliefs, which constitute the essence of secularism in India. Protection under Articles 29 and 30 is not a privilege, but a protection to religious or linguistic minority communities to attain equality with other religious or linguistic groups of India. It is a constitutional mandate that the linguistic minority is entitled to conserve its language as well as culture. Now, let's understand the meaning of minority. The term minority is not defined anywhere in the Constitution. It means a non-dominant group. It represents the smaller of two members, sections or any group. In the case of reference case, that is Kerala Education Bill 1958, the Supreme Court observed that the minority means a community which was numerically less than 50%. Minority was to be determined only in relation to the particular legislation which was being challenged. If it was the state law extended to the whole of the state, a minority would be determined in relation to the entire population of the state. In the landmark case of TMA Pai Foundation versus State of Karnataka 2002, the Constitution Bench of the Supreme Court held that since the reorganization of the states has been on the linguistic lines, for the purpose of determining the minority, the unit will be the state and not the whole of India. A linguistic minority under Article 30 Clause 1 is one which must have a separate spoken language, and that language need not to have a distinct script. A linguistic minority is to be determined with reference to the language spoken by the community. People speaking such language having no script of its own constitute a linguistic minority for the purpose of Article 30 Clause 1. A minority based on religion means that the only and principal basis of the minority must be adherence to one of the many religions and not a sect or part of the religion. A minority based on religion should be restricted only to those religious minorities which have their identity separate from the majority. Article 30 Clause 1 uses the word linguistic or religious minorities. The word or indicates that minority may be either linguistic or religious, and that it does not have to be both. In TMA Pai Foundation versus State of Karnataka 2002, the Supreme Court held that minority has to be decided according to the state in which the educational institution is established. Minority is what numerically less than 50% is. This position is with regard to linguistic as well as religious minorities. The Parliament has enacted the National Commission for Minority Institutions Act 2004. The commission set up under this act has to decide all the questions relating to the status of any institution as minority educational institution and declare its status as such. Any person who desires to establish a minority educational institution has to get NOC, that is, no objection certificate, from the National Commission. Now, let us come over to the constitutional framework of the minorities. Article 29 and 30 protect certain cultural and educational rights of religious, linguistic minorities in India. Article 29 clause 1 provides that any section of citizens residing in the territory of India having a distinct language, script or culture shall have the right to conserve the same. Article 29 guarantees the right to conserve one's own language, script or culture. Now, to claim this right, the following conditions must be satisfied. Number 1, the right can be claimed by any sections of society. The right belongs to the citizens and not to the others. Number 2, that section of citizens must be residing in the territory of India or any part. Number 3, that section of citizens must have distinct language, script or culture. In another landmark case, that is of DAV College Jalandhar versus State of Punjab, the Supreme Court held that setting up of Guru Nanak Dev University under the Guru Nanak Dev University Act 1969 at Amritsar to promote the studies and research in Punjabi language and the literature and to undertake measures for the development of Punjabi language and culture did not infringe Article 29 clause 1. The court further held that the promotion of the majority language did not mean stifling of the minority language or the script. Article 29 clause 1 does not refer to any religion, even though it mentions the protection of interest of the minorities. Article 29 clause 1 is not subject to any reasonable restrictions. The rights conferred by the citizens to conserve their language, etc., are made absolute by the Constitution. Clause 2 of Article 29 provides that no citizen shall be denied admission in any educational institutions maintained by the state or receiving aid out of the state funds on the ground only of religion, race, caste, language or any of them. The benefit of Article 29 clause 2 is not confined only to minorities, but it extends to all citizens whether belonging to minority or to majority. Article 29 clause 2 does not create an absolute right for the citizens to be admitted into any educational institution maintained by the state or receiving aid out of the state funds. It does not prohibit denial of admission on the grounds other than religion, race, caste or language. Now, let us see what is the difference between Article 15 and Article 29 clause 2. There are significant differences between Article 15 and Article 29 clause 2 of the Constitution of India. Article 15 clause 1 protects all citizens against discrimination by state on the basis of caste, religion, gender, place of birth, residence, etc. Article 29 Clause 2 extends protection against the state or anybody else who denies the right conferred by it. Moreover, Article 15 Clause 1 protects all citizens against discrimination generally in all matters, whereas Article 29 Clause 2 gives protection against only a specific kind of discrimination, that is, denial of admission. Further, Article 15 Clause 1 prohibits discrimination on the grounds of gender or place of birth also, but Article 29 Clause 2 does not mention any of these grounds. Now, we will talk over what is the right of minorities to establish and administer the educational institutions. Article 30 Clause 1 provides that all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Article 30 Clause 2 provides that the state shall not discriminate educational institutions on the ground of minority in granting aid to them. The benefit of Article 30 Clause 1 extends only to linguistic or religious minorities and not to any other minority. Linguistic or religious minorities have the following rights. Number 1, right to establish the educational institutions. Number 2, right to administer educational institutions of their choice. What is the object of Article 30 Clause 1? The object of Article 30 Clause 1 of the Indian Constitution is to give the minorities a sense of security and a feeling of confidence, not merely guaranteeing the right to profess, practice and propagate the religion to religious minorities and the right to conserve their language, script and culture to linguistic minorities. The object is to enable the religious minorities to profess, practice and propagate their religion secured by Article 25 Clause 1 of the Indian Constitution, as also to the linguistic minorities to conserve their particular language, script and culture, and to give a thorough good education to children belonging to the minorities. In another landmark case of 1987, that is Frank Anthony Public School Employees Association versus Union of India, the Supreme Court held that the idea of giving special rights to minorities is to give them a sense of security and a feeling of confidence. In St. Xavier's College versus State of Gujarat, 1974, the Supreme Court held that the spirit behind Article 30 Clause 1 is the conscience of the nation that minorities, religious as well as linguistic, are not prohibited from establishing and administering the educational institutions of their choice for the purpose of giving their children the best general education. In St. Stephen's College versus University of Delhi, 1992, the Supreme Court held that the minority under Article 30 must necessarily mean those who form distinct and identifiable group of citizens of India. In TMA Pi Foundation case, the Supreme Court held that the expression educational institution means institutions that impart education, including education at all levels from primary to postgraduate as well as professional education. The word establish and administer, what is that? Article 30 Clause 1 guarantees to the minorities the right to establish educational institutions of their choice. The word establish means to bring into existence. It does not necessarily connote construction of the institution by the minority. It means the right to establish real institutions which will effectively serve the need of their community and the scholars who resort to them. The minority is not required to seek prior permission for the establishment of an educational institution. Article 30, Clause 1 does not require that the whole community must have been involved in the establishment of an educational institution. Now, the word establish and the word administer in Article 30, Clause 1 have to be read together. Minorities can claim the right to administer an educational institution only if it has established it. The Supreme Court in the St. Xavier's College versus State of Gujarat and in the case of TMA Pi Foundation versus State of Karnataka held that right to administer educational institutions consist of the following matters. Number 1, right to choose managing or governing body. Number 2, right to choose teachers. Number 3, right to admit students of their choice subject to reasonable regulations as to academic qualifications. And number 4, right to use the properties and assets for benefit of institution. In another case, that is of SP Mittal versus Union of India, 1983, the Supreme Court held that in order to claim the benefit of Article 30, Clause 1, the community must show it is religious and linguistic minority. Number 2, the institution was established by it. Without now satisfying these two conditions, the benefit under Article 30, Clause 1 cannot be claimed. In the case of S. Aziz Basha versus Union of India, 1968, the Supreme Court held that Aligarh Muslim University is not a minority institution. The court spelled out that the minority will have the right to administer the educational institutions of their choice, provided they have established it and not otherwise. Now, what is the difference between Article 30, Clause 1 and Article 26, Clause A? Article 30, Clause 1 and 26, Clause A both secures the right to establish educational institutions. To this extent, they overlap. They differ in the following respects. First, Article 26, Clause A secures the right to establish institutions to the majority as well as the minority communities, whereas Article 30, Clause 1 secures the right to the minorities, linguistic as well as religious. Number 2, Article 26, Clause A refers only to religious denominations, whereas Article 30, Clause 1 contains the right of religious as well as linguistic minorities. Third, Article 26, Clause A provides that the religious denomination have the right to maintain the institution established by them. Article 30, Clause 1 secures the right to a minority to administer their institution. Fourth point, while the rights secured by Article 26, Clause A is subject to public order, morality and health, whereas Article 30, Clause 1 does not specifically mention any such conditions or restrictions. Now, what is the extent of regulations by the state? Prima facie, it appears that the freedom guaranteed under Article 30, Clause 1 is absolute in nature. It has not been made subject to any reasonable restrictions. In this connection, the Supreme Court in reference Kerala Education Bill 1958 held that the right conferred on the religious and linguistic minorities to administer the educational institutions of their choice is not an absolute right. In the case of Frank Anthony Public School Employees Association versus Union of India 1987, it was held that the regulatory measure aimed at making minority institutions effective instruments for imparting education without nullifying management's rights are permissible. In the case of St. Xavier's College versus State of Gujarat 1974, the Supreme Court once again held that the right to administer does not mean the right to maladminister. Regulatory measures such as syllabuses, courses, curriculum, minimum qualification of teachers, superannuation, health, etc. can be imposed. These regulatory measures are there to promote educational standards and maintain the uniformity. In TMA Pai Foundation versus State of Karnataka 2002 and PA Inamdar versus State of Maharashtra 2005, the court held that considerations for granting recognition to a minority educational institutions and casting accompanying regulations would be similar as applicable to a non-minority institution subject to two overriding conditions. First, recognition is not denied solely on the ground of educational institution being one belonging to the minority, and number two, the regulation is neither aimed at nor has the effect of depriving the institution of its minority status. In the TMA Pai Foundation case of 2002, the Supreme Court laid down the following guidelines. First, the state is to be regarded as a unit for determining linguistic as well as religious minority. Number two, institutes which receives aid from the state could be subject to government rules and regulations. Number three, in respect of any unaided institution, only regulation which the government may put is regarding the qualifications and minimum conditions of eligibility of teachers and principals. Number four, conditions of recognition and affiliation by or to a board or university is to be complied with. Fifth, an aided institution has to admit a reasonable number of non-minority students. Sixth, minority institution may have its own procedure and a method of admission, but the procedure must be fair and transparent. In Islamic Academy of Education versus State of Karnataka, the year 2003, the Supreme Court held that the educational institutions can have their own fee structure, but there must be no profiteering and capitation fee cannot be changed. Subsequently, in PA Inamdar versus State of Maharashtra 2005, the Supreme Court clarified some issues raised in TMA Pai's case and Islamic Academy's case, and accordingly the Supreme Court held that minority educational institutions may be classified into three categories: those which do not seek aid or recognition; second, those who want only aid and no recognition; and third, those who want recognition and no aid. The court held that those which do not seek aid or recognition may exercise their right without interference, and the remaining categories may be subjected to restrictions and conditions. Each minority institution is entitled to have its own fee structure, subject to the condition that there can be no profiteering and capitation fee. Unaided professional institutions will have full autonomy in their administration, but the principle of merit cannot be sacrificed. Right to administer does not mean right to maladminister. Without interfering with the autonomy of unaided institutions, the object of merit-based admissions can be secured by insisting on it as a condition to the grant of recognition, and subject to the recognition of merit, the management can be granted. Neither the policy of reservation be enforced by the state, nor can any quota or percentage of admissions can be carved out to be appropriated by the state in any minority or non-minority unaided educational institutions. Further, and very recently, the Supreme Court in Christian Medical College Vellore Association versus Union of India 2020 year upheld the validity of the National Eligibility cum Entrance Test (NEET) for admission to medical and dental courses. The Supreme Court held that the right conferred on religious and linguistic minorities to administer educational institutions of their choice is not an absolute right, and it is not free from any regulation from the state. Now, let us shift to the relationship between Article 29 Clause 1 and Article 30 Clause 1. In St. Xavier's College versus State of Gujarat 1974, the Supreme Court held that number 1, Article 29 Clause 1 confers the right on any sections of citizens including minorities, whereas Article 30 Clause 1 confers only to religious or linguistic minorities. Article 29 Clause 1 is concerned with the language, script and culture, whereas Article 30 Clause 1 deals with the minorities based on language and religion. Next, Article 29 Clause 1 deal with the right to conserve language, whereas Article 30 Clause 1 deals with the right to administer educational institutions. Now, let us come to the conclusion. The right of the minorities have been protected under Article 29 and 30 of the Indian Constitution. The minorities have the fundamental right to protect their language and culture and establish and administer educational institution of their choice. The idea to give the status of the fundamental rights to educational right of the minorities is not inequality towards the privileged class, but a sense of security to the minority groups. It is very much necessary to protect the certain legal rights of minorities to uplift their position in the society. Article 30 of the Constitution of India allows the minority to establish and set up their own institutions, which has been proved beneficial to the minority community in terms of their educational growth. Thank you everyone for your time and attention. I appreciate this opportunity to speak with you today, and I hope that everyone has understood the topic. Stay safe, stay healthy. God bless you all. Take care.